Hello there, welcome to part 2 of your course, Attending District Judges' Applications in Chambers. We're going to be looking at case study 1, which is a charging order absolute. This part will hopefully add further skills to those you've already attained in part 1, ones that you may not normally expect, in particular the skill of advocacy. This is the skill most associated with the job that barristers do, and attaining this skill will give you more scope for work as it's an area where paralegals could specialise, and paralegals do have a right of audience before a district judge in chambers. That basically means that you can stand up before a district judge and present your client's case to the court. So mostly this will be small claims, of course, before a district judge in chambers, but it also applies to most tribunal cases. In fact, the history of county courts is such that they were called small claims courts because they were originally created in 1840 to create a platform for litigants who couldn't afford to pay for lawyers and who wanted to deal with their case themselves. In those days, the maximum claim allowed was £20. It's changed a little bit since then because now the maximum is £10,000. So in this part, we'll be looking at 3 different case studies, all of which are quite common for paralegals to deal with, and all of which are real cases with names and dates changed. Most of this part of the course will involve you analysing the case file. That means basically reading it through thoroughly, every document on the file, understanding what it is and how it will help you to present the case to the court. Hearings in chambers before a district judge are quite informal. Evidence is presented without being on oath, although of course affidavits could be part of that evidence. The judge doesn't even wear a wig or a gown. There are several new terms we haven't come across before: agent and instructing solicitor. So please see the definitions of these on page 5 of your study notes. With regard to the letter on page 4 of your course material, you are asked several questions in the action bit on page 6 of your study notes. Have you got the answers ready? If not, please pause this and come back in a moment. Welcome back. The answers to each questions are as follows. Who will be relying on the application and the affidavit? The answer is you, because you are the freelance paralegal and you will be presenting the case to the court. So if you're using this to present the case to the court, what does that make it? It makes it evidence. And if it's evidence, what should you do with it? Of course, you should read it. It's important that when you're reading through the rest of the documents in your file, you try to understand each one and how they relate to the case, and how it will help you, of course. You'll notice that there were several letters sent to several different parties notifying them of the hearing. You may be wondering why that is. Well, the first is to the defendant, Mr. Regan. The second is to his wife, Mrs. Regan. Why would she be getting this letter? Well, maybe she co-owns the property and therefore has a right to know what's happening with it. We are at this stage, of course, making assumptions because we haven't yet finished reading the content of the file. The third letter is to the Woolwich Building Society. Maybe they granted the original mortgage, we don't know. The fourth is to the NatWest Bank, and the fifth is to Barclays Bank trading as master loan. We may not yet be sure about these last 2, but we could make the assumption that both have at some stage lent money to Mr. Regan. So are you getting a picture of what Mr. Regan is like? He certainly likes to borrow money and doesn't like paying it back. But it's not until you read the charging order nicely that you get an idea of the chronology of what has gone on with Mr. Regan. You will note that on the 12th of April, a county court judgment, a CCJ, was granted. On the 1st September, the charging order NICE was granted, or NICE was granted. And on the 26th of October, there will be a hearing to decide whether the NICE or NICE will be made absolute. If Mr. Regan hasn't come up with the money, it most certainly will be granted. Also, there is another affidavit referred to in the charging order, NICE, in the first line, that of Mr. S. Eveshaw. When reading through his affidavit, we realise that he is the person dealing with the case at the client's company. He also refers to another exhibit, SE1, which is a copy of what they call the land registry entry documents relating to Mr. Regan. And as it transpires, Mrs. Regan as well, they both seem to own the property. Every time a property exchanges hands, it has to be recorded at the land registry. This is what we call office copy entries. And it is by getting a copy of this that we now are aware of the other creditors of Mr. Regan, namely the Woolwich, NatWest and Barclays, familiar names we've also encountered. We're also now sure that he co-owns the property with his wife and can now understand why she has a right to know about the hearing also. Clearly, Mr. Regan has not responded to anything, and we're therefore not really expecting him to turn up at court. However, we have to be prepared if he does turn up. Now, you should not be put off if he does arrive at court. You may be a little bit surprised, but you shouldn't be put off. Maybe you should be wondering why he's decided after all this time to be there when he's ignored everything else. Maybe he wants to pay. That would be good for our client. Maybe he wants some money on the horses or the lottery. We don't know. So it's probably a good idea, and I know that you're probably not happy about this, but it probably will be a good idea to go up to him before going into court to just introduce yourself. And this may prompt him to hand you some cash, possibly. And if he does so, you shouldn't touch it. You should phone your solicitor, your instructing solicitor, to get permission to take the money in full settlement of what is owed. And if you do speak to your solicitor, you should then accompany Mr. Regan to your solicitor's office, and if the job has come through an agent solicitor, please look that up in your terminology, then you will be assured that the agent solicitor's office is near the court and that you should go to that office. However, before you do so, you have to cancel the hearing that is due in court. You have to go to the usher and cancel it to say this is settled. However, complications may arise if you can't get authorization or permission to accept any offer he makes, because maybe your solicitor isn't around or he's in a meeting and you can't get to speak to him. And that means that even though Mr. Regan has come along to pay, you should really go ahead with the hearing because you've been given no other permanent instructions. So you should always go ahead with the hearing if you can't get permission to accept his offering. And never assume that permission will be given. You can never take that for granted. And so, on arrival at court, there is an on-arrival script on page 18, which is virtually the same as the one you found in part 1 of your course material. There's just one thing that I haven't mentioned, which is when you introduce yourself to the usher as being present and ready to go into court, did you say, "I'm here in the case of Midland Bank, versus or v Regan? If so, it's wrong. You should also always refer to a case as Midland Bank and Regan. Even though V does stand for versus, you should never say that. It's always and. That's just a little tip from me to you. This is the end of OT 11. Thanks very much, and see you at the next one.